Is now live. It's our pleasure to welcome now Christopher Green, law professor at the University of Mississippi Law School. Professor, always good to see you, sir. Thanks for coming on.
Good to see you. Exciting days these days.
They are. So it seems like we have gotten ourselves into a mode where, and it just didn't start with the election of the current president, but really seems to have gotten underway under the prior administration. Presidents sort of test the boundaries of the Constitution and executive power in the executive branch, and they issue these executive orders with a swipe of a pen, and inevitably somebody's mad about it, doesn't like it, doesn't agree. And so their remedy, I guess, is to file a lawsuit, and somehow these lawsuits kind of trace their way all the way up to the highest court in our land, that's the Supreme Court, and they end up having a rule on it. And so we have one. We've been talking about it this morning about some of those rulings. This one had to do with the president's action in deporting someone and an illegal in this country and invoking a law to do so. Is this? It just feels like this is going to continue. What say you, Professor?
Yeah. So these last two. So there's Trump versus JGG about deportation proceedings, and then just last Friday, Department of Ed versus California. So both of these, I mean, makes your eyes bleed in terms of how detailed they are. They're both about where you're allowed to sue to challenge certain actions. So, if anybody who's unhappy with what the president is doing, so this happened under Biden, happens now. If you say that any trial court can just, run any litigant anywhere in the nation can run to somebody, well, there's certain places in the nation where you can be extremely confident that you're going to get somebody sympathetic to your claim. So the education one was in a Massachusetts court, and they ended up saying it had to be filed with the Federal Court of Claims. The immigration one, it was filed in the D.C. courts, and they said, well, actually, this should have been a habeas corpus petition, which would have meant filing it in Texas. So essentially what these two decisions are about in an emergency posture. Are you allowed to go to just any district judge or some of them say, like, oh, we got to go to D.C., but a bunch of questions about basically who is allowed to do these emergency things. Also, a bunch of procedural stuff about if they do these emergency things, what kind of review do we have? I look at all of it, I really think Congress really needs to come in and set some rules about really the immediate appealability of a TRO, temporary restraining order, and coming up with some rules about where you do these kinds of challenges. In other contexts, they do have a system. So if an agency makes a decision and you have multiple petitions to circuit courts, they actually have a lottery system under the great Section 2112. So you can listen to your Rush music while you have that lottery going on. But they don't have anything like that for the TRO level. And I think Congress really, it would be good if they could do this. I don't think it's going to be able to be done kind of in the current administration, like in time to get these emergency things handled in a more orderly way. But really, by 2029, we've got to have a system that's more orderly than this, where you don't have people picking and choosing their judges the way we can. It's I think it's unseemly, and it doesn't promote careful consideration of legal issues the way you want if you're going to have the rule of law.
And it seems like that the court inevitably and really not by design, but rather almost by default, because of the way these things go down, they get inserted into the political process, even though they're supposed to be separate from it, of course. That was the design, the brilliant design of our founders and of course, our founding documents and system. But inevitably, it becomes politicized, whether they wanted to or not.
Oh yeah, yeah, and you get. I mean, part of it is that the immediate appealability question has a huge amount of discretion built in. So you've got these things, temporary restraining orders. Technically, they're not supposed to be immediately appealable, but preliminary injunctions are. So there's a big question: do we
Okay.
characterize this TRO as a PI? And it really is kind of sometimes in the eye of the beholder. So I mean, these 5-4 decisions, they weren't the same 5-4. So one of them,
Huh.
Justice Barrett dissented. One of them, Chief Justice Roberts dissented. So there had been some, I think, kind of wildly overheated criticism of Barrett, but she was actually the one that was on board putting this spending clause or this spending limitation. What was it? It was limits on spending that were enjoined by the District of Massachusetts last Friday. So if she had been, thinking, oh, I'm just going to oppose Trump at every turn, well, that would have been 5-4 the other way. So
Yeah.
there's some difficult calls, but I do think a lot of the criticism of individual people over individual justices over individual decisions is. I think it's incorrect. I think it's unfair criticisms, but also it's not strategic. Like, if you want to, promote these folks' decisions in other cases, you gotta respect their decisions when they happen to disagree with you.
Yeah. Well, I don't think this is over. So what's on the docket?
No.
What's on the horizon? What are some of the key cases and high-profile cases you expect to come before the court?
So the real biggie that's coming down, probably, I mean, it could happen any time now, is a case about who the president is allowed to fire. So there's this old case from 1935, Humphrey's executor, that basically allows Congress to create a kind of headless fourth branch of government. And it has been tottering. A couple of justices have said we need to overrule it, but I was actually very surprised that Trump did not mount an assault on this precedent the first time he was elected. I mean, his whole slogan was "You're fired." So, but the second term, he has definitely taken aim at Humphrey's executor. So, really, at any moment, probably this week, the Supreme Court is going to make a decision about whether some firings, whether those firings are going to be able to take effect immediately. They could say, well, leaving people in the office temporarily, but a challenge to Humphrey's executor is definitely coming. They probably won't have a full-dress decision about that issue, just whether to put the president really in charge of the executive branch, in charge of all of the executive branch. Probably won't have a decision on that super soon, but we'll definitely get some tea leaves. So I expect some spicy activity on this, the emergency docket. I've got my refresh button on my SupremeCourt.gov going, and there's a couple of different links you gotta check to see if something exciting has happened, during an interview. But there's definitely spicy stuff coming.
The birthright citizenship is an issue. Where does that stand?
Yeah, that one, it's a little unclear just how much percolation that's going to get before it gets to the U.S. Supreme Court, because there's a question of like, well, what exactly turns on this issue? So if the Trump, it's a lot of the decision about the timing is up to the administration. On the birthright citizenship, I think they probably are thinking that they want it to be a little more delayed. Stuff like Humphrey's executor, people, they go to law school, they get a view on it. It really makes sense to just go in and just get the decision, so you can start firing other people. But the birthright citizenship, I think, would require a lot more thinking from the courts. I think it's probably an outside shot of the administration winning in any event, but delaying it probably makes most sense strategically for them. Try to give people like the law professors of the world, give them a chance to really dig into some of these arguments and see if you can make a better argument for overruling some of the precedents or distinguishing some of these statutes carefully. But that is a big uphill battle. Again, Congress could come into the game. Congress could say, because there's a bunch of statutes that a lot of people have read, is like, yeah, this basically grants birthright citizenship. Congress could get in the game and modify those statutes. So I suspect that the administration, what they would, the most likely ground to win on would be waiting for the scholarly world to get at least a few more months of work done, and then also, if you can, get Congress in the game. But getting Congress in the game is well, that's hard as we know.
It'd make it a lot easier, though, for the courts if we had statute that was clear to rely on. Professor, always good talking to you, sir. Thanks for coming on. Appreciate it.
Good to see you. Take care.
You bet. We're coming right back in the Element Wealth Studio.